Our firm works on a contingency basis, and what that means is we only get paid once our clients get paid. So we front the cost of all the litigation, and if something were to happen and the client yielded zero, then we would just be out that money. We don't ever call up the client and say, we're going to need you to write us a check for the expenses we've incurred. But it's a good system because what it causes us to do is to take the claims that we believe in, the claims that we think are meritorious, and the ones we know that they're going to be successful. So we always front all the costs, and the client's not out anything. And eventually, the costs do come out of the client's portion if the client receives a settlement or a verdict.
Just adding to that, and that's exactly the way it works. When a client comes to us, we do not charge a retainer fee. We don't charge an hourly rate. The client is out no money from the inception of the lawsuit. These cases can be very expensive to prosecute. We have to hire doctors. We have to hire experts. We have to hire all the different expertise that's necessary to carry our burden of proof. We're the plaintiff. We're bringing the case. We have the burden of proof. And so, as you might imagine, doctors charge large sums for depositions and medical record reviews, things like that. We pay all of those expenses during the pendency of the lawsuit all the way up until the settlement. And as Dewana mentioned, during the process of pursuing the case, the law firm pays for all the expenses associated with the case, the experts, the doctors, the depositions, the travel, all the necessary expenses associated with any litigation are paid by the law firm. And in the unlikely event that a client does not receive a recovery, they do not get a bill at the end of the case.